Today we're going to talk about the case of John Weney versus, and I think that's how you pronounce that, W-E-N-E-Y, Weney, maybe it's Weney, versus Workers' Compensation Appeal Board, Mac Sprinkler Systems Incorporated, excuse me. This case came out in 2008. Typically I do more recent cases, but I think this case is important because it's, in my opinion, we're starting to see a trend, if you will, by the Commonwealth Court with regard to whether and how many times and when you can amend the injury description to something different. So, brief facts of this case, of course, is a workers' compensation case of Pennsylvania. So the facts of the case are simple. 2005 injury, fell from a ladder, left shoulder strain. He was unable to work. Employer issued a TNCP, which was later converted to a full NCP. So they picked up the case. 2006, claimant files a petition to review to amend the NCP. Very close. We're still within 3 years of the date of injury. Actually under 1 year. Files a petition to change the description of injury to include a tear of the labrum and a large joint effusion, tendinitis, or a partial tear of the supraspinous infraspinatus, impingement, and biceps tenosynovitis. So what the attorney is trying to do here is expand and more clearly define the description of the work-related injury. Of course, TNCP, that's filed by the employer. They could put whatever they want on that document. The claimant has no say in that matter. The claimant has to file a petition to review that controlling document if the claimant wants to change the description of injury. And by the way, the employer can do the same thing. The employer could always go in and file a petition to review to change what's on the accepted document. So, in any event, petitions filed, the parties enter into a stipulation, and they agree that the NCP should be amended to include the additional injuries asserted by the claimant. May 19, the judge issues a decision adopting the stipulation and granting the claim petition. Nobody appeals. Okay? So we have a TNCP, and then an NCP, a petition to review, a stipulation of facts, and a judge's decision. All looks fine and dandy. Great. Not a problem. Then what happens? Less than, I don't know, was that 21 days? Couple weeks, 19th to the 30th. So it's, 21 days. So 3 weeks later, claimant files another petition to review. Now the claimant wants to add herniated discs. C2, C3, C4, C5, and C6 at all levels, claiming these were all sustained in the work injury. And what happens? The defense attorney says, hey, wait a minute. We just did a stipulation of facts, and we identified what the injury was just a couple weeks ago. So the employer files an answer. They allege technical res judicata and or collateral estoppel. 2 hearings are held. Claimant testifies he experienced pain in his neck immediately after the work incident. He reported this to his treating physicians. Claimant presented deposition testimony of Dr. Fitchy, who opined claimant had herniated discs in his neck. Employer presented deposition testimony of Dr. Levin. He did an IME in August of 2006, which actually would have been, let's see, just looking time-wise, I wonder if they related it back to the original independent medical evaluation. The second review petition was filed in May, so no, they got a new IME. Levin said claimant may have sustained a cervical strain on the job. I hate when doctors do that. I mean, give us an opinion, yes or no. You know, just tell us what is the injury in your opinion. Don't say may have, possibly, could have. In any event, which temporarily exacerbated the underlying condition of cervical spondylosis and disc generation. Just say the claimant had previous problems, for crying out loud. But in any event, the judge issues a decision in which he credited the testimony of the claimant, and the judge found claimant sustained herniated discs on the job. Found the NCP was materially incorrect to the extent that it did not reflect these injuries, granted the claimant's review petition, and amended the NCP to include the herniated discs. Judge, interestingly, doesn't even address technical res judicata and collateral estoppel. just ignores that argument completely. Employer appeals to the appeal board. The board opines as follows. Yada, 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 big, long explanation here. And basically the bottom line is the appeal board says, hey, claimant was aware of the work-relatedness of the neck injury during the prior litigation. He should have raised it at that time because the parties were addressing additional injuries that claimant sustained as a result of the October 2005 fall. So they say review petition is barred. Goes up to the Commonwealth Court. On appeal, claimant makes various arguments. Employer makes various arguments. What's the appeal board say? We're going to begin our review with a brief explanation of the doctrines of technical res judicata and collateral estoppel. And for you non-lawyers out there, Latin. All right, we love to use Latin. I don't know why we just don't use the English phrases anymore, but for anybody out there listening to this that hasn't taken Latin in high school, like I took 4 years of it, not that it helped me at all. Res judicata. Res is the thing. That's a Latin word for the thing. Judicata. Was decided. Was adjudicated. I guess the vernacular today would be, we already did this. we already went down this road once already. We already looked at this question. That's you could say this the same thing. We done this already. Been there, done that. I think that's the best the best English translation of res judicata would be been there, done that. Collateral estoppel. Not really Latin, but I guess estoppel has a Latin derivation. Collateral estoppel means just like collateral damage. Kind of the same English translation or street translation of collateral estoppel would be collateral damage. We already did this. We're stopped. I think that might be French. I'm not sure. I'm not an English French major here. We're stopped from looking at this question again. Similar to res judicata, but collateral estoppel is a little different. Collateral estoppel really is, this should have been decided before, and now we're stopped from looking at it. So slightly different than res judicata. This was been there, done that. This is been there, should have done that. That's the best, in my opinion. You know, I get 1,000 lawyers that give you 1,000 different, and everybody, the lawyers are all going to give you, you know, the really complicated, long, drawn out explanation of collateral estoppel, because that's how we get paid. We get paid by giving you the long answer. I'll give you the short answer. Res judicata, been there, done that. Collateral estoppel, been there, should have done that, and failed to do it. So anyway, if you want to read the lawyerese, you can do that. But basically, you know, Commonwealth Court says technical res judicata, also referred to as claim preclusion, to make things even more complicated. When a final judgment on the merits exists, a future suit between the parties on the same cause of action is precluded. In other words, been there, done that. To have technical res judicata, you have to have the identity of the thing sued upon, or identity of the cause of action, identity of the person's party, and identity of the quality or capacity of the parties to be sued. It's just, to me, quite honestly, basically you got to have the same parties fighting about the same thing. That's what that says. You want to summarize that? That's the same parties fighting about the same thing. All right? Technical res judicata may be applied to bar claims that were actually litigated as well as those that should have been litigated. And claims that were actually litigated really is a different concept in my mind as an attorney. Claims that were actually litigated, to me, is really the law of the case doctrine. You know, when you have a claim that was actually litigated and you have a judge that writes a decision and you fought about whether the claimant was injured, whether the claimant gave notice, whether the claimant was disabled at that time, that becomes the law of the case. And that's a claim that was actually litigated. So, but in any event, res judicata applies to things that actually were litigated in the past and things that should have been litigated in the past. Causes of action are identical when the subject matter and the ultimate issues are the same in both the old and the new proceedings. So collateral estoppel, a little different. Issue preclusion as opposed to claim preclusion. it's designed to prevent relitigation of an issue in a later action, despite the fact that the later action is based on a cause of action different from the one previously litigated. All right, so for claim preclusion, collateral estoppel, the issue decided in the prior case is identical to the one presented in the latter case. There was a final judgment. The party against whom the doctrine is asserted was a party or in privity with the party in the prior case. The determination in the prior proceeding was essential to the judgment. Turning now to the present case, after they give you all that stuff, you could think of it a much simpler, been there, done that, or been there, should have done that. All right, that's collateral estoppel, res judicata, summarized for people that speak English. Here's what the Commonwealth Court says in the Weney decision. I'm going to say Weney. All right, that's what I think it is. The subject matter of both the review petition 1 and 2 was the nature and extent of the injuries that the claimant sustained as a result of the work injury. And the ultimate issue in both proceedings is whether the NCP accurately reflected the nature and extent of the claimant's injuries. All right? So they say right there, it's satisfied. Although the claimant did not actually litigate the specific issue of his neck or cervical spine during the earlier proceeding on his review petition, the record evidence clearly establishes that he should have done so. All right, he should have litigated that issue. He knew about it at the time. Claimant testified he experienced neck following the October 21, 2005 work incident, and that he had reported experiencing such pain to his treating physicians. His doctor testified claimant first came to him for treatment March 27, 2006. He complained of cervical neck pain. He also testified that the MRI performed in April 2006 revealed disc herniations. Cross-examination, he said he saw him in March of 2006. Whether he advised claimant it was related, he said, yeah, I did. I told him it was work-related. So there you go. So the claimant was aware of the injury to his neck or cervical spine and its relatedness to the work injury during the proceedings in the first review petition, which went from March to May of 2006. So it says here, claimant is correct in his assertion that Section 413 of the Act gives a WCJ the authority to amend notices that are determined to be material incorrect. Right, we can't get around that. That's in the statute. The actual Workers' Compensation Act says judge has authority to change the notice of compensation payable if it's materially incorrect. But Section 413 must be applied in a manner that's consistent with res judicata and collateral estoppel. The purpose behind the Act is to provide quick and certain benefits to employees who suffer work-related injuries. So the Commonwealth Court goes on to hold the doctrine of res judicata maintains the integrity of the workers' comp system. If we were to allow amendments to notices of compensation payable in situations such as this, the result would be that litigants could file piecemeal review petitions without any justification for doing so, thereby requiring others to continually waste time and resources defending against issues that should have been raised in earlier proceedings. Commonwealth Court says, we believe the General Assembly intended for litigants to raise any issues of which they are aware and know to be related to the particular work incident during the same review proceedings. Claimant relies on these other cases, but they say that reliance is misplaced. He knew about it, he should have litigated it, therefore he's precluded from amending. Now, what's interesting is, did this case go further? And we go back here to there's a 2015 one, but this seems to be a rather common name. Let's do this. We're going to search on Google Scholar the Atlantic Second citation. That's rather interesting. The only one that comes up is the decision by the Commonwealth Court. But here's one. I'm sorry, I stand corrected. Here's one called Namani, A. Dewey Pyle, decided by the Commonwealth Court December 6, 2011. And let's see. We're just going to scan through here very quickly. and see what they said. Once again, in this case, they cite the Weney decision in 2011, so it's still good law as of 2011. The doctrine of res judicata applies and precludes the amendment modification of the NCP to include alleged additional cervical injuries. The results of the EMG were available to claimant's medical expert prior to filing the employer's termination petition in 2005. Therefore, the issue of whether claimant suffered a cervical injury could have been litigated during the termination proceedings. As such, the employer sought to terminate claimant's benefits based on a full recovery of the injuries to his left hand and arm. Claimant at that time should have filed a petition to modify. So this is interesting because what the Commonwealth Court is saying here is when the claimant is faced with a termination petition and there's other injuries, they should file a review petition. And they should amend the NCP to include the cervical injury. Claimant did not and may not seek to correct that oversight now. And then he cites two other cases, Taylor and National Fiber Stock Corporation. But they say that's misplaced. Those cases were different. Okay, so that's as of 2011, there's still, Commonwealth Court is still citing the Weney versus Max Sprinkler Systems case. Here's one from 2012, Scott versus Delaware Regional Planning Commission. This is an open records issue, so that's not a workers' compensation case. But they cite it. It's important because they're still citing it in 2012. Here's 2013. And once again, they're discussing the issue of collateral estoppel and res judicata. Let's just jump down. I'm not going to go through the entire case. You could go on to Google Scholar and read that if you like, but let's see what they decided. They cite the collateral estoppel argument. They cite Weney, the 2008 decision. Appeal denied. So here we go. So the Supreme Court of Pennsylvania denied the appeal of the claimant in Weney. So that Commonwealth Court decision stands unless it's been reversed by the Commonwealth Court or subsequently reversed by the Supreme Court of Pennsylvania, but I don't think it has been. Once again, I always put this, this is July of 2015, so if you're listening to this at a later date, you always want to go back and check the law because anything I say here today could be changed by the Commonwealth Court or the Supreme Court of Pennsylvania tomorrow. So they cite Weney. The board determined that collateral estoppel applied here because the original litigation, this court agreed with the WCJ's conclusion that the medication claimant took as a result of the work injury rendered him incapable of performing the no-duty job because he had difficulty meeting the requirement of staying awake. Employer argues that collateral estoppel does not apply here. Oh, I see. So what happens here is, in this case, in the Channel Lock decision, Reynolds, collateral estoppel is actually used against the employer. So the issue in the original litigation was whether the no-duty job was available to claimant because employer required him to remain awake while at his post and the medications he was prescribed as a result of the work injury caused him to fall asleep. So they go on and on. It looks like the employer was not successful in this case. Res judicata was used against the employer. Still good law, though. 2013, that is. Here's Depew. I have a vague recollection of the Depew case. This is 2013. And again, they cite the Weney decision, so it's good law. The judge apparently concluded that in this case the review petition was barred by res judicata because claimant was aware of the left shoulder injury and agreed not to include it in the CNR agreement. And they cite Weney, okay. Interesting. We go forward in time. For the most part, here is a 2015 decision where the Commonwealth Court is still citing the Weney decision. And let's just jump down to the last page of the decision here and see what we find. So they affirm the appeal board. And, once again, they agree collateral estoppel barred the claimant from challenging whether the treatments at issue are reasonable and necessary. So this must have been in a UR review. Claimant filed a UR within 2 months after the WCJ's decision. There's no showing the claimant suffered a legally adequate change of condition. Thus, this case falls squarely within the parameters of CDG, and Gary is inapplicable. Interesting. So still good law, still applies to this day. The Weney decision is still the law of the land. As far as I'm concerned, claimant's attorneys will always try to find a way around it if they have failed to file a review petition on time. And honestly, I see this a lot. And the reason I think claimant's attorneys are hesitant to file a review petition is it takes time and it takes money to litigate a review petition. And there's really, quite honestly, aside from the fact that the description of injury has changed, I can't see a downside to doing it, especially when you have something like an IME that agrees that this injury is work-related. That should be filed automatically by the claimant's attorney, I think, at that point, and just go into the judge and say, Judge, this should be picked up and the NCP should be changed now. Otherwise, we're in a violation situation, unreasonable contest situation. Once again, should you have any questions, feel free to give us a call at any time.